Decree talk number 2. Captain Jeremy and Captain Adam here to lead the conversation or maybe just ask your questions. We'll see how that works. So number one thing, though, before we get going is if you can just hold the questions just for a second, we'll be happy to get to those. We got a little overwhelmed last time we did this with all the questions. So just hold the comments for a few seconds. We're going to give a little intro and then have Steve talk a little bit about his history and involvement in this. So with all that being said, we do appreciate people's willingness to have appropriate dialogue last time, and we just expect that same to carry through tonight. I think that this is the best way for us to get your questions answered and just good, honest information out to all of the sportsmen out there. So without further ado, we'd like to introduce, this is Steve Schultz. He is with the Coalition, and he has been involved in the decrees, the 1985, 2000, 2007 inland decree, and then most recently this one. He knows more of the history of this than anyone that's available. He's an awesome resource, and we would like to introduce him. And here he is. As soon as I find the right button to push, there we go. Mm-hmm. Welcome, Steve. Thank you so much for joining us tonight. And we truly appreciate your time and your knowledge.
Well, I'm happy to be here, and let's see if I can impart some of that knowledge, such as it is.
Awesome. Well, if you want to maybe just kind of give us a brief history of, your experiences with this, even though it's not brief experience, and just kind of give a little background of yourself, and then we'll kind of get this thing going.
Yeah, little did I know in 1979, when I was only 4 years old, that the senior partner in the firm I was working for asked if I wanted to get involved in something having to do with tribal fishing rights. And this was just within a month or so after Judge Fox had issued his opinion in May of 1979, declaring the treaty right that we all honor today. And there was a vacuum, though. There was a regulatory vacuum at the time, and there weren't any rules by which the tribal fishery undertook to fish after Judge Fox's opinion. And I got involved in it again in 79 and 80, and finally was involved in the negotiation of the first consent decree, which was signed in 1985. An interesting thing about that first decree, even though I was representing a number of resource groups and MUCC was involved, and we weren't parties to the case, the tribes and the feds and the state were parties to the case. For whatever reason, Judge Enslin at the time asked if I would serve as the lead counsel to coordinate all of the proofs being put on by those parties supporting the decree. So I was one of the only non-taxpayer supported lawyers at the table. But we successfully implemented that decree. 15 years later, we were involved in negotiations for the decree that became the 2000 decree. In both of those negotiations, we were allowed to participate. We met with the mediators. We met with the state. We met with the tribes. We had good dialogue in both of those negotiations. And then starting in about 2019, the process started all over again, looking for the current decree that's at issue here. So we had throughout the first two negotiations a very good working relationship between the Department of Natural Resources and the members of the coalition. And it allowed us to have some input. It allowed us to provide some feedback, and it allowed us to, at the end of the day, sign on to the decree. And I would say during the last 20 years, 22 years now, we've had a good relationship with the department and frankly with the tribes as we've worked through our problems. Unfortunately, since about the 1st of July, our relationship has soured a little bit. And we largely have been outside the negotiations looking in um, because of a breakdown in communications with the Department of Natural Resources. But here we are. Um, I think probably the reason we had that breakdown in relationship is because we held a different idea as to the approach to be taken to the fundamental issues facing the parties in these negotiations. And again, here we are. So with that, I can talk a little bit about kind of the context in which we find these negotiations, if you'd like, or we can just start taking questions.
I think a little context here would be good to kind of get the questions rolling. So kind of a general overview from your perspective would be awesome.
Sure. So the starting point for negotiations is the treaty right. There isn't any question that that treaty right exists. There is no question that it gives the tribes an absolute right to fish in the Great Lakes. The question is, how is that treaty right exercised and going to be exercised, however? It's our view that the Great Lakes fishery is a fishery shared in common between the state and the tribes. It's a fishery that is shared roughly 50-50 between the state and the tribes. And that, for us, presented the following conundrum. It would be very difficult to negotiate a decree if the parties didn't agree on those two fundamental principles. One, that the treaty right exists and is to be honored. And the second is that the resource is shared roughly 50-50. And without a commitment to those two fundamental principles, it would be very difficult to negotiate any kind of an agreement as to how the fishery is to be divided and how the fish are to be pursued. And I think one of the difficulties in this negotiation that we saw, at least, was it did not appear that there was a universal commitment to the concept of a roughly equally shared fishery. And without that commitment, you could negotiate and negotiate and negotiate, but at the end of the day, without a commitment to that fundamental principle, I doubt that you're going to get everybody to agree to a consent decree. And what that fundamental principle led to, at least in the first two decrees, was zones, tribal zones, state zones, shared zones, that helped to resolve issues of gear conflict, that allowed the recreational fishery to pursue sport species in their zones. It allowed the tribes to pursue commercial species in their zones. And then there were lake trout and other kind of dual purpose species that would be pursued throughout the lakes. But what those first two decrees did with the zone concept and with a recognition of the shared nature of the resource is they allowed each of the parties, the recreational fishery and the commercial fishery, tribal commercial fishery, to catch their share of the resource. And laid over the top of that was a long-standing commitment to lake trout rehabilitation. For decades, the federal government, the state, were committed to lake trout rehabilitation. And so besides these two fundamental concepts, you had to figure out how you were going to accomplish lake trout rehabilitation. And one of the things, at least initially, that appeared to be a very important factor in lake trout rehabilitation was the reduction of non-selective fishing gear, particularly large mesh gill nets. And that was because, simply put, lake trout and whitefish tend to operate in the same waters at the same depths at the same times a year. And so the issue of bycatch of lake trout while targeting whitefish became quite an issue. And I say that because those earlier negotiations led to a reduction in gill net effort, in exchange for which the state gave up some of its 50-50 allocation. So there was a trade-off, there was a contract, there was an agreement, and both parties, we think, benefited from it. We're concerned about whether there's still that commitment to lake trout rehabilitation with what we've seen in this decree. And I'll leave it at that, and we can move on.
Yeah, so we got some questions coming in now. So the first question is, it pertains to Bay de Noc. They're asking where their Great Lakes Fishing Association group is, in the negotiations. But maybe I don't think that we have a great understanding of the changes that this decree brings to Bay de Noc, Big Bay de Noc specifically. We did talk a little bit about Little Bay de Noc last time, but if you could maybe just give a little oversight of what changes this decree would bring to those areas.
Yeah, happy to, because there are some significant changes to the Bay de Noc zone. In the 2000 decree, Little Bay de Noc was largely closed to tribal commercial fishing, and that continues. But Big Bay de Noc was closed to large mesh gill net fishing. And in this decree, it has been reopened to large mesh gill net fishing. In particular, there's essentially totally 24,000 feet of large mesh gill net that can be fished in Big Bay de Noc. 12,000 feet are essentially allocated to the Little Traverse Bay Band, and 12,000 feet are allocated to the Sault Tribe. And there's a limited number of operations. There's a limited amount of feet per license that can be fished. So I think Little Traverse gets 3 operations and Sault Tribe gets 4 operations within that 12,000 feet. There's a bag limit for walleye. It's 15 pounds daily from January 1 through May 14. But otherwise, it's a gill net fishery now. And that is a dramatic change from what occurred in the 2000 decree.
So the bag limit after May is non-existent, or just to clarify?
Well, that's interesting. The decree says that there's a 15-pound daily bag limit for walleye from January 1 through May 14, but it's silent as to what occurs after that.
And it's pounds or fish?
Pounds.
Pounds. Okay. So
yeah.
And then what about salmon in that area? Are they allowed salmon catch?
Salmon is not a commercial species in most of the Great Lakes. There are additional salmon opportunities up and down the Great Lakes, and there's a bag limit for salmon. But salmon really isn't addressed in the Bay de Noc area specifically.
Okay. So I think kind of continuing on that, so we talk about the addition of all of this gill net. Joe Wirtz asks, do you see a 50-50 allocation with the current decree that's being negotiated with adding the gill nets? Do you still see that 50-50 allocation can maintain, I think is what he's trying to say.
Yeah, well, first of all, it's probably more like a 60-40 allocation right now. But putting that aside, the parties supporting this draft decree are saying, look, the allocation overall is not changing, with the exception of Lake Superior. But in Lake Michigan and in Lake Huron, the allocation between the state and the tribes is staying roughly the same. So don't worry about losing your sport fishing opportunities, because the tribes aren't allocated any more fish than they were under the 2000 decree. And in a macro sense, that's true. But by authorizing significantly more gill net fishing opportunities to the tribes, you create the following conundrum. Under this draft decree, I'll give you an example. The charter boat industry is obligated to report on a regular basis. And they're going to have to report electronically, and they're going to have to give the grids that they fish, the fishers that were on board, the fish taken and the fish released, the species and the like. Well, a sport fishery, a hook and line fishery, is a very inefficient fishery. You need a lot of fish congregated in an area for hook and line to be successful. A gill net fishery is a very efficient type of fishing that can take a lot of fish when they're congregated in a very short period of time. And that's what we saw way back when the treaty right was first declared by Judge Fox, is we had an inundation of gill net fishing opportunity that took a massive amount of fish in a very short period of time. Now, we're not going to have that kind of unlimited racehorse fishery now, but you have the following scenario, and that is, let's say you're allocated 6,000 feet of gill net, and you know that at a particular time of year, at a particular depth, based on the charter boat data, that lake trout congregate in a particular place. That gill net, being far more efficient than a hook and line fishery, can go in and take the tribe's allocation from that congregated area in a very short period of time. And from the tribe's perspective, it makes sense to do that, because you have to make fewer runs, you have less expense, and you can catch more fish in a shorter period of time. You're still staying within your allocation, but now in an area where fish congregated and the sport fishery was successful because it was a non-gill net zone previously, you now have a big hole in the water. And the other thing to point out is, under the old decree, the tribes could fish trap nets, and they did fish trap nets, but they had to return the lake trout to the water. They could not retain lake trout. With gill nets, you don't have that option.
Yeah.
So you're left with the same overall allocation, but with gill nets that are easy to move, very efficient, very effective. They can fish those areas where the fish congregate at particular times of the year, take their allocation, and leave that area where there would not be the equivalent sport fishing opportunities as we had in the past.
So here's another question from Wayne County Federation of Sportsmen's Clubs. How many tribal licenses will be given out, and what does it mean that the tribes can contract out their fisher?
Well, if I assume that last part of the question relates to the Little River Band zone, and in the Little River Band home waters, there's only going to be 2 operations fishing gill net. Each of them can fish up to 6,000 feet of gill net. And they're tribal operations run by the tribe. But interestingly enough, the language for that zone says that the tribe can operate those 2 fishing operations themselves, or they can hire a tribal employee, or they can hire an independent contractor to come in and run that operation for them. Now, this brings up another problem with the decree that we see. Independent contractor is not defined. And so that independent contractor apparently could be anybody who's qualified to operate a fishing boat. It doesn't necessarily have to be a tribal member. It could be a member of another tribe, which they've had the right to do in the past, but it could be a non-tribal member who's contracted to run that operation. And while the operation is supposed to be for purposes of historic preservation and cultural education, that's easy to declare and hard to enforce. And the language in the decree says that although the fish harvested by that gill net operation are supposed to be used for these goals, fish that aren't needed for those goals can be sold commercially. And right now, I think there's a good working relationship between the Little River Band and the sport fishing community, and you hope that it continues. But, you know, in politics, the world rolls over on somebody every 4 years. And so this is a 24-year decree, and you don't know what the future holds in terms of those kinds of relationships. And we really think there should have been a great deal more detail and checks and balances on those kinds of operations.
So we have a few questions coming in, and there's a lot of questions pertaining to this. And I'm hoping that maybe you can just bring some clarity to it. And the main concern, I think, with a lot of fishermen, at least in the southern portions of the fishing areas here, is that, so let's just give you a scenario like the fall, the salmon are running up the river in the fall. Can they put their nets across the mouth of a river and catch those salmon? And
Well,
if they do that, can they sell them? And if they're, I guess maybe you can answer that part first.
yeah, salmon are not a commercial species under this decree, and they were not a commercial species under the previous decrees. So there's no change there. And there are limits in terms of how net can be set around stream mouths and harbor mouths and the like. And there has to be some effort to allow fish passage. So in terms of actually targeting salmon, there are specific places where targeting of salmon is permitted, but generally the rule that it's not a commercial species holds. So I don't think that's the issue so much as it is the issue with lake trout in the southern Michigan zones.
Sure. Yeah, I just wanted to get that clarified because, you know, my understanding is that there is an opportunity for allowable bycatch of salmon, but that just pertains to the vessel. It can only what can be actually on the vessel, and it's still not for sale. They still can't not sell that limited quantity.
Yeah, I mean, it begs the question more what might happen in the future versus what we've seen up to date. And let me just mention something. Even though salmon are not a commercial species, there will be some bycatch. But the big issue in Lake Michigan is the lake trout. And I say this because the salmon are sometimes there and sometimes they're not. And the question is, how do you run or have a good recreational fishery if you only have a single species to pursue?
Yeah.
And that's why the lake trout are important. And that's why targeting of lake trout in such a way that it leaves kind of a hole in the water is a difficult proposition for us.
Here's another good question that kind of pertains to that walleye statement that you made about where they talk about the time, 15 pounds of walleye from this area. The question is, does nothing mentioned mean that the fishing is closed, or does it mean that during those time frames there is no limit on the catch?
The treaty right is an absolute. So unless there is a provision that limits that treaty right, then at a minimum there's ambiguity as to the scope of the right and what can be exercised and what can't be exercised. But if it doesn't say you can't pursue walleye, then you can pursue walleye. That's the problem. And and that was a challenge for the folks representing the Bay-de-Noc area in these negotiations last summer. Was that the 24,000 feet of gill net in Big Bay-de-Noc was going to be very, very hard to stomach.
And is it all large mesh?
It's
And-
a large
and-
mesh gill net.
Okay.
Yeah.
So here's another question that came in from Tom. He is asking if they have increased the catch, the bycatch on perch and walleye. And he's
Well,
from the Badenoch area, so I would
There-
assume it's kind of relevant to that.
Yeah, there are increased opportunities throughout Lake Michigan and Lake Huron for perch and walleye fishing. And the rules are essentially the same for both. In the 2000 decree, there were a dozen grids in Lake Michigan that were available for tribal gill net fishing for perch and walleye. And there were 10 grids available in Lake Huron. In the new decree that's being proposed, there are 81 grids open to walleye and perch fishing in Lake Michigan and 23 newly opened grids in Lake Huron. So the areas where walleye and perch can be pursued have been expanded significantly from what existed in the 2000 decree.
So kind of on that same, well, this is another question from the same gentleman. He asked, as far as, I mean, everybody is kind of aware that all of the tribes are in agreement with this except for the Sioux Tribe. So if the Sioux Tribe does not agree to this moving forward, are they allowed to fish without restrictions because they don't sign on to this?
Well, that is something that the court is going to decide. We're certainly not. But I will tell you that the Sioux Tribe is, in my view, the tribe that declined to accept the 50-50, roughly equally shared resource. And they have asserted that they intend to regulate themselves and determine how their fishers shall fish. And I will say it presents a challenge not only for the recreational fishery, it sets forth a challenge for the other tribes and for the state of Michigan and for the federal government. Because it's, I think, probably well nigh impossible to have two sets of managers trying to manage one resource. And so, you know, they're going to make that request of the court to be allowed to regulate themselves, to set their own limits, to enforce their own rules against their own fishermen without being part of this decree or without being part of some other organization that sets forth limits on their activities. And I think the risk to the resource as a whole and to the recreational fishery is profound.
Yeah, I think, I mean, here's another question that kind of is in that same, with your statement that you just made. Is the stance of the coalition the same as the DNR on the gill nets being used, and believe that gill nets will have very little bycatch of silverfish? So I guess it goes back specifically to silverfish. And I mean, I think that we can maybe answer a little bit on that too. So I have a good friend who is a biologist. He runs research nets on Lake Michigan. He does this on a regular, almost like a 6-month window. And he's using gill nets, large mesh, all the way up to, I think, 10-inch mesh, and as small as, I think, 1.5 inches or something like that. And he's doing fish surveys with these. Now, the proposed gill nets, large mesh, are 4.5-inch nets. And in his experiences fishing, he sees limited impact on silverfish with a 4.5-inch net. That being said, it doesn't happen. You know, I mean, an occasional fish is could get entangled, but the design of the net is if you're if your head fits through it, it can get you, unless your body also fits through. So you're talking about probably more juvenile sized salmon that would fit, probably maybe 4 to 10 pound range salmon, and they would have to be somewhere that was fishable with the net. So I mean, the biggest concentration of salmon is in the fall. You're talking about mature fish in the fall. I would think from what he has told us and what other biologists have told us, it would be a limited impact on silverfish in that time frame when you have that concentration. You do need a concentration of fish to be able to catch them, or a pinch point or something like that. Is that kind of...
I think
go
we
along
share
with
that.
your...
Yeah, I think we share that view. I think, there's going to be some bycatch of salmon, but for example, in the Little River Zone, but I don't think it is going to be as significant as the bycatch of lake trout or the actual targeting of lake trout.
Yeah.
And I think if you think about, in the fall when the fish are congregated, we stand to put a much larger, have much more influence on the silverfish fishery in even one charter boat or in a fleet of charter boats per day than what they are going to do with nets as far as silverfish go.
Yeah. And remember too, at least in July and August, the Little River Band's not going to be fishing.
Yeah, because that is closed in Manistee and ports of Manistee and Ludington. But however,
that doesn't help ports like
Muskegon,
Pentwater,
Pentwater,
Muskegon,
right?
fish.
But at least in Ludington and Manistee, they won't be fishing.
Actually, can I get you to weigh in on this? Because this is a question that I had the other day after I talked with Dave, or actually we did. The warning labels placed on our fish in the Great Lakes as far as being unsafe for consumption or consumption in very limited amounts. Is that a concern in a commercial fishery for the tribe to be able to sell fish that have known, high levels of heavy metals and some other compounds?
Addressing that is beyond my pay grade.
Yeah. I think it's a good question, though. I mean, how can how can these fish be sold if that's true? I don't know. It's curious.
So there's a lot of questions that have come in pertaining to the coalition being left out of the negotiation. They vary from why were they left out to what happened to make that decision, and then also who is actually excluding you guys from the negotiations.
We had difficult disagreements with the department over the approach to the negotiations, as I think I've mentioned earlier on this evening. We had differences over strategy. We had differences over the willingness to provide gillnet opportunities. And then we had differences over what we felt were actions that undermined our ability to carry on negotiations with the tribes or to offer up solutions that we thought were better. It kind of came to a head in the month of June, and the representatives from the Bay de Noc and the coalition representatives had a very difficult meeting with the Department of Natural Resources and their team. We left that meeting, and the Bay de Noc folks left that meeting. And after that, we found ourselves in a situation where we were no longer being provided with information from the state related to the negotiations, even when we asked for it. And let me explain the dynamic. Because we're not a full party to the case, but we're an amicus curiae, a friend of the court directed that our participation in the negotiations would be through the state of Michigan. In other words, we could not sit at the table and make our own proposals. We could talk to the parties if they were willing to talk to us. But if we had positions that we wanted to take or questions we wanted to ask, they had to be asked through the state. And similarly, proposals that went back and forth had to come through the state to us. Once we had this breakdown in the relationship in June of this year, things like proposals and counter proposals stopped coming to us. And we asked for them, and we were denied the opportunity to get those documents. In fact, in August at a session, we were finally provided a rough draft of a decree, and one of the tribal council pointed out after we got it that what we had gotten was not the current draft, and there'd been lots of changes to it. We asked if we could see the changes, and we were told no. So we were basically closed out of the negotiations by the parties from about June 30th on. And we asked even for drafts once, and to show you how consistent the behavior of the parties was, when the parties announced to the court in September that they were close to a final decree, we asked if we could see a draft of what they'd worked out so far, and we were told no. The first time we saw this document or what anything really close to it was when it was released on Sunday night, December 11th.
Can I ask a follow-up question, Steve?
Sure.
At this point, given that things have come on paper, and at least it's been released for us to see, do you think there's an opportunity to repair that relationship? And I don't mean to ask a super loaded question, but we have really not imparted our thoughts and our feelings. But one thing I'm willing to, that I want to say is we feel that we really need someone in there that's representing the sportsmen in the state of Michigan. And, we really believe firmly that you guys should be a part of that. Is there an opportunity to come back to the table? Is there something that can be done to repair that relationship at this point?
I would certainly hope so. Because I do think there's more that we have in common with the department than we lack in terms of common purpose and objective. Mm-hmm. We can disagree without being disagreeable. But right now things are not very good. And so maybe once we get through these objections and get through the Sioux motion, I mean, we're clearly aligned with the state in terms of our view of the Sault Tribe's efforts. But time will tell, and I would hope that we could repair it.
Yeah, and I mean, I think that anything that we can do to help in any way, we're more than willing to do that. So, yeah, I think that a good conversation with a group of individuals could maybe be a first step or something like that. We do have some other questions coming in. This one from David. He asked, how can someone get involved and voice our concerns with this decree? Well,
in terms of concerns specifically with the decree, there's going to be we're going to file objections, and the Sault Tribe is going to file objections to this decree on or before January 20 in court. And then the state, the 4 tribes supporting the decree, and the federal government will respond to those objections, I think by early March. March 6th sticks in my mind. At which point the court will then decide whether it's just going to hold a hearing or it's going to have reply briefs or whatever. But sometime March or April, this thing will probably come to a head in terms of the objections and the responses. So, and that there isn't an opportunity to get directly involved with other individuals or parties. Beyond that, I think about the only thing that you can do is express your concerns to the department or if you have a good working relationship with the tribes, to the tribes. I mean, I don't fault the tribes one bit for the positions they took. They are negotiating in their best interest. That doesn't mean that the decree that comes out of all of this couldn't be a little bit better.
And with all of the things, there's more questions about salmon, it being caught and targeted, but salmon are not, for the new to this decree, gill fishing, salmon are not a target species, and they're not something that can be sold. There are opportunities where that happens at Nuns Creek and a few different things. But as far as if you're, especially if you're in the Little River area, they're not going to go out and target salmon. They can't do it. They can do it. They could technically target them if they wanted to, but they have no value to the tribe, and they can only possess a limited amount. So, I mean, I think common sense says that they wouldn't target non-target species. It would be a lot of work for no gain. So I don't know if that kind of helps. I know a lot of people are super concerned about the silverfish, and which it totally understand, but you really should be very concerned, I think, with lake trout, because if large mesh gill net's going to affect any game fish that we as an industry or we as a group of fishermen target, it's going to be lake trout. And everyone knows that lake trout grow at a super slow rate. And, if you're catching a 10-year-old or a 10-pound fish, it's probably 10-year-old fish. So if you go in and take out, all of the 10-pound fish, then you're not going to see concentrations like that again until, that population slowly, more fish come into that area, which is a pretty slow process for lake trout. They're generally found in similar areas over and over and over. So I think that maybe hopefully clears that up a little bit. There is a good question that I'd love to hear you talk about, Steve, and it comes from Mike. And he says, could you please talk about the enforcement policies on the current decree? So if there is some kind of a violation, what is the procedure?
That's a very significant concern that we have. And let me put that question in context. In the 2000 decree, there were some general standards for enforcement. But there were specific penalties associated with overfishing. And roughly they for lake trout, it went something like this. If in a year, either the sport fishery or a tribal fishery caught 15% more than its allocated lake trout, then the following year they had a penalty they had to pay. And that was to give back the fish that they took over their allocation. And what that, of course, when you have a penalty like that is going to hit you fairly hard the next year. And I'll give you an example. If your allocation was 30,000 pounds and you took 15% over 4,500 pounds, the next year, instead of 30,000 pounds, you would only get 25,500 pounds. If you went 20% over, you'd get fewer and fewer. So the penalty was immediate, and it was predictable, and it creates quite a deterrent to overfishing. And the state suffered penalties, for example, in Grand Traverse Bay one year, and the tribes suffered penalties in some instances. But generally, people stayed within their allocations. Those penalties, those clearly stated, enforceable, unambiguous penalties, no longer exist in this draft decree. The only thing that is in this decree is 3 general statements. The first says that large deviations shall be rare and promptly addressed. Now, I don't know what a large deviation is. Is it more than 15%? Is it less than 15%? Is it 50%? Is it 5%? I don't know what it is. And it's not defined in the agreement. And then it says large deviations shall be rare. What does that even mean, rare? Does that mean if you have more than one deviation in 10 years, you have a problem? Or does that mean if you have a deviation every year, you have a problem? I don't know what the standard is. And then it says promptly addressed. And I have no idea what promptly addressed means, but I can tell you this, the dispute resolution process will take 3 to 6 months minimum to resolve a dispute between the parties over whether some penalty should be paid for overfishing on the state's part or the tribe's part. The second standard is that it says on average, neither the state nor the tribes shall exceed their apportioned harvest opportunities. So again, this is language in a contract that's supposed to last 24 years that refers to on average. What does that mean? Does that mean an average over 2 years? Does that mean an average over 5 years? We're going to evaluate stocks only every 3 years now instead of every year. So does that mean an average over 3 years? I have no idea what on average means, and it's not defined in the document. And then it says, not their apportioned harvest, but it says their apportioned harvest opportunities. Is a harvest opportunity the actual catching of fish? Or is it where you can fish? It's an opportunity to fish? Is an opportunity to harvest? That language is so vague as to be unenforceable. So you take language like that and you don't have the same kind of enforceability of the standards that the parties are supposedly setting forth for themselves. And that becomes a real challenge if there's overfishing on the state's part or if there's overfishing on the tribe's part.
Yeah, I mean, from what I'm hearing of your all of your answers, that a lot of the problems in the document are that there aren't enough written. There's not enough. There's too many. I wouldn't call them loopholes, but just too many things that are kind of vague and not defined.
Yeah.
Absolutely. I mean, there's some things that are not vague and undefined. The expansion of gill net opportunities, as we've talked about earlier this evening. But then there are things like this enforceability that is very vague and not defined. And I'll give you one other one that is a head scratcher. There's a provision in the decree that largely follows the 2000 decree on how stocks are going to be evaluated and allocated, and how you're going to determine what the allowable surplus is to be caught. One of the critical things in evaluating the surplus of a stock is the mortality rate. In other words, how many fish are killed in a year by natural causes, by lamprey, and by fishing mortality. And this decree says that this decree will not become effective until the mortality rate for lake trout is defined, and the decree does not define the mortality rate for lake trout. So I don't even know how this document is in front of the court, because it says the executive council has to approve the mortality rate before this decree can be executed, and the mortality rate for lake trout is not defined. And that's critical, because we're starting to see some natural reproduction of lake trout in Lake Huron and in Lake Michigan. And the mortality rate for lake trout is going to be critical if you're going to continue lake trout rehabilitation. And whether that mortality rate is 50% or 35% makes a huge difference on whether you're going to have naturally reproducing lake trout in Lake Michigan and Lake Huron. And it's simply not addressed and undefined, even though the party said it's a condition of having this agreement become effective.
So we have a few more questions coming in. one is a good one, I think, from Nate. Well, I think they're all good questions. I shouldn't be. Yeah. Anyways, but Nate asked a question that is, so is there going to be a allotment of how many lake trout can be caught per maybe grid section, or is it like the Little Rivers grid? Could they catch all their lake trout from one area, or is it defined that it has to be spread out, or how does that lay out in the document?
That's a very good question. And let me address it this way. The allocations in terms of the available catch to the tribes or to the state are not set by grid, but they're set by management unit. So for example, there's an allocation for MM4, the Grand Traverse Bay area, where Grand Traverse Band will get a gross allocation and the state will get a gross allocation. As to where those fish are caught within MM4, that's up to the parties. And that's why, going back to my comments about the efficiency of large mesh gill net, is it is conceivable you could take a large percentage of the allocation for a management unit out of a single grid. I'll give you another example that's probably even better. In MM5, in discussions with the Grand Traverse Band, we actually did reach some agreements on the limitation on how many lake trout can be caught in particular grids in the month of May. And that was to prevent that grid from being targeted for month after month and leaving no lake trout there for the sport fishery. So it's the grid immediately off of and north of Leland, and it's the grids immediately south of Leland going down to Good Harbor Bay. And so we had a good discussion about that and the need to spread that take out so you don't leave a hole in the water.
Yeah, I mean, if you're a fisherman in general, you don't go back to the same. It's not a good technique to go to the exact same area and fish your limit every day. Sooner or later, there's nothing left,
Right.
And especially fish that are slow growing and not huge migratory fish. Here's a question that came in: Are the tribes bound by the requirements of the current decree until the new one is in place? Does the 2000 decree have an expiration date? And if so, what happens if there is not a new one before, if the old decree runs out and there isn't a new one in place?
Yeah, it's a good question. The 2000 decree technically expired on August 8th of 2020. It has been extended, I believe, 7 times by the court under an order, and most of the time through agreement of the parties, to kind of fill the gap in regulations and rules for the fishery until the new decree was resolved. The last extension by the court was an indefinite extension until a new decree is approved. So the 2000 decree is still in place, and I would think would be in place at least into the month of March 2023, if not farther, depending on how the litigation goes.
Sure. So another question, Tom asks, on page 36 of the proposed decree, the list of species not authorized for commercial harvest. Salmon are not on that list, so salmon are authorized for commercial harvest. Well, there is, just to clarify, Tom, there is opportunities allowed in the current decree for salmon harvest. So I imagine that's why that is not listed as one of those fish, but I don't know if you can just clarify that.
Yeah, you answered the question very well. There are Nuns Creek and various other places, salmon can be targeted by the tribes. And so that's why it's not listed there. But in other areas, most other areas, salmon are not a commercial species to be pursued.
And yeah, and then you bring up, or he brings up the point that it says retention of more than 200 pounds per vessel per day of salmon caught are incidental catch in gill nets.
Correct.
And Jeremy and I have had this conversation, and Jeremy and I have done this together in a all legal setting on a charter. Caught more than 200 pounds of fish in one morning. It's fairly common. So I mean, I know a lot of people are really hung up on the silverfish thing and the protection of the silverfish. If that's your major concern, I do believe that in many of the areas, my understanding is that large mesh gill netting, as proposed in this, has little effect on silverfish. But the lake trout thing is tremendous, and I think people really need to understand the ramifications of what could happen, or how this could play out and affect a small area for a long period of time.
I think the same, we have to think in the same terms of how we have fished certain areas too heavily as a sport fishing community, and we have definitely damaged the lake trout population. I mean, I could think of Holland would be a good example. The area off the golf course in Arcadia, that's not the same fishery it used to be, and that's a lot largely in part from our effort. So I think this concern is huge as far as netting heavily in one area continuously.
Logan has got a good question here. He says, Steve, has the court vocalized or the specific objections that the Sault Tribe has with this document? Has there been any information as to what they are opposed with the document?
Well, the Sault Tribe has not indicated specific objections to the terms of any specific term of this proposed decree, but they have indicated, as I mentioned earlier, their desire not to be part of the decree and to set their own rules and regulate themselves and basically go it alone. They are obligated to file their they have one motion pending already over that issue, and they are proposing a second motion to challenge the court's jurisdiction to order the decree to apply to them. And that motion has to be filed by next Tuesday. So we'll know more about their position in that respect when it's filed next Tuesday. As for any discussions or objections that they have with respect to the proposed decree, they have to file their objections, if any, to the proposed decree on or by January 20th, just as we do.
So there's a few questions that have come up pertaining to could the state trade something to keep gill nets out of this decree? I mean, in your opinion, in my understanding of everything that I've seen, gill nets are going to become a part of this. In the language is probably what could be changed at this point. Is that kind of your similar take on this?
Well, you raise an interesting point. In the 2000 decree, the state spent $14-15 million to buy trap net operations from state licensed trap net fishers. And they gave those free of charge and with training to representatives of the Sault Tribe and a couple of the other tribes at the time. And the idea was that they would convert their large mesh fishing effort into trap net fishing effort. And they committed in the 2000 decree to take 14 million feet of large mesh gill net out of basically northern Lake Michigan. And the point at that time was to facilitate the rehabilitation of lake trout and make sure that all of those lake trout that were being taken in gill nets targeting whitefish would now be taken in trap nets and would be returned to the water alive rather than dead. So it was aimed at lake trout rehabilitation, and we took 14 million feet of gill net out of the water. It was our view that that obligation continued after the 2000 decree expired. The state did not share that view and did not seek to enforce that reduction in gill nets in these negotiations. And they did not seek to extend that reduction in gill nets in these negotiations. So, that's the kind of the first short answer, is that limitation on gill nets in the state's view went away. So there was immediately a request for additional gill net fishing opportunity. The second thing that I'll say is that trap nets are more expensive to fish with the decline in whitefish, and lake trout being the perhaps preferred species on a go-forward basis, at least in the short run. You needed a cheaper way to fish, and the tribes were certainly going to ask for it. The question is, did we have to give in so easy? I mean, the amount of additional gill net opportunity is striking. There literally is no water, with a couple of very small exceptions, in Lake Michigan that will not be available for tribal gill net fishing if they choose to do so. Now, is it, a full out fishery? No, it's not. But it presents the challenge of that gear being fished everywhere in Lake Michigan. Similarly, from Rogers City north, including on the lake trout refuge in northern Lake Huron, gill nets may be fished 10 months out of the year. And now in Lake Superior, gill nets may be fished in all of the treaty waters in Lake Superior, where before the line was basically at Munising. Now it goes almost all the way to Marquette.
Yeah. Vince asked a question here. It's kind of more enforcement, I think, than anything else. I mean, is there provisions? And I think Dave did specify a little bit about this, but are there provisions for gear that is abandoned or gear that is unchecked and left for weeks or months or even years? And then also, other fishing equipment. Is there provisions in the decree to maybe remedy that or to have some kind of a recourse?
Yeah, there's provisions on law enforcement and cooperative law enforcement. I don't see that changing much from the other decree. When abandoned nets have been found, boats have gone out and pulled them, but there are occasions when they're not pulled soon enough, I guess. So nothing really, I think, in that respect is going to change as to enforcement. The difference will be that there will be now large areas of the lakes where you didn't have to worry about abandoned or lost gill nets, that now there is that possibility. Again, not highly likely, but gill nets are not anchored as trap nets are, and there is always the possibility of losing a net or abandoning a net.
The answer, I think, that Dave gave to that is, if you had a specific concern, to call the RAP line, same as you would any other fishing game violation.
Absolutely, and that was the remedy under the 2000 decree.
Yeah,
sure. Someone from a private account had made a statement here, and I do believe that this is something that should be kind of touched on. Legally, we can't mandate the gear that the tribes use. The tribes are allowed to take their portion of the allocation of the resource by means that they find fit to do. And unless we negotiate some other deal, then they would have to agree to a limit on the gill net situation. Is that correct?
Well, yeah, let me put it a little differently. And one of the attorneys involved in these negotiations kind of summed it up. The resource, as I said at the beginning of this discussion, is roughly shared 50-50. That's our view. I think that's the view of most of the parties. And one person said, it's roughly 50-50, but if you want gear limitations, such as reduction in gillnet or areas where gillnet can't be fished, you're going to need to give something up for it. And I think what the state did in 1985 and what they did again in 2000 is they gave up a portion of their allocation in order to get restrictions on gillnet fishing. And so, the tribes take closer to 60% of the catch every year, and the state takes closer to 40%. But in exchange, the recreational fishery had zones where there were no gill nets to compete with. So, yeah, the tribes are free to fish with what gear they want, but if that's all we're talking about, then they only get 50% of the resource, not 60%. If you want 60%, what are you going to give us for it? And what we've gotten for the last 37 years is restrictions on gillnet fishing to avoid the kind of gear conflict and targeting conflict that would prevent the sport fishery, the recreational fishery, from getting its fair share of the resource.
Joel, a good friend of ours, he asked a question: Does the decree allow for nets to be set outside of the seeded waters? So outside of the decree, I mean, the decree is only the waters within. It's all specified
The treaty.
in the
Right.
treaty.
Yeah, basically the waters north of where the Grand River comes into Lake Michigan, Grand Haven, around to just north of Alpena, as I think Dave mentioned, and then basically Lake Superior east of Marquette. And no, if the tribes fish with that gear outside of those boundaries, then they don't have a treaty right to do so, and I guess law enforcement would have to decide how to deal with it.
Sure. And then, is there any recourse that sportsmen have? I mean, is there a voice that sportsmen have? Can they contact legislature? Can they do anything to improve the situation? As far as with the gill nets, is there anything that can be done at this point?
Well, they can certainly express their displeasure if they're displeased with the expansion of gill nets and with the nature of this decree, to their legislators, to the department, to the governor's office, whatever. That's about the only recourse they have. They can support the coalition, which includes MUCC and the Michigan Steelheaders and the Michigan Charter Boat Association and the Grand Traverse Area Sport Fishing Association, the Hammond Bay Anglers. There are a number of organizations that banded together to basically be the recreational fishers' voice in these negotiations. And they can always use the support.
So, yeah, for sure. I think, the coalition has been involved in this for many, many years, and many, many decrees as far as that goes. And, I think if you're willing to help them, they're probably your strongest voice as far as the interest of sportsmen. I mean, you guys represent us, and in these negotiations to the best of your ability, or to the best that you're allowed to. But that's our voice in this. I really do believe is the coalition. As far as there's some comments in here about lake trout. Is there even a market for lake trout? And I think that was a discussion. I don't remember who we had. Jeremy and I have been talking with many people about this for about 2 weeks now, and many, many, many hours of conversations with many awesome concerned people and biologists and all of that. I think that the problem is, if you tried to make a profit selling lake trout by catching them with trap nets, it would be probably not. It would be hard to profit in that manner because a trap net is a pretty substantial operation. And, I do believe that that's why the use of gill netting is being thrown on the table, because you have to lower the cost of entry and the cost of actually collecting the fish. Not everyone will go spend $200 on fuel to catch 4 silverfish over the course of a weekend. But, some of us do, but we're not in the commercial business of doing that in that manner.
200?
I'm trying to relate with everyone. Yeah, or thousands of dollars in fuel in a weekend. If you drove slower,
maybe, can't.
Throttles don't have to stay all the way down. You can bring them up. There's this other speed. It's like, anyway, I don't encourage to go slower. So then also there's a question that says, is there a black market for bycatch? Now, there has been issues in the past where fish has been caught and sold and illegally, right? And I just want to remind everyone that there was tribal people involved and non-tribal people involved. This isn't what this is about by any means. And if people see an opportunity to make a quick buck, all people may consider doing it. And does it make it correct? No. And there's laws and there's enforcement, and there was a huge enforcement and a sting involved on that scenario. But this isn't like, we're not trying to paint anyone in a bad light here. I mean, truly it's one resource that we're all sharing, and we really need to be doing what's best for that resource. So I just want to kind of put that out there. And then also that for the vast majority of situations, and as far as this treaty compared to the 2000, there's really not more opportunities for salmon to be sold. There's similar opportunities that were already in place, and it's not people aren't going to go out and target salmon all over the lakes to provide a commercial market for. It's not in the decree. The decree does not allow it. And that's fairly well specified in this new decree. Is that correct, Steve?
Yeah, I mean, the rules on salmon are fairly well specified. They've expanded a bit in terms of the waters where they can fish, just like with walleye and with perch. But generally, it's not a commercial fishery.
Yeah. And then there's, the gill net issue. They're not being given the gill nets they're not being allowed. I don't know how to word that. It's not that we're giving them this right. They have the right to use the gill nets. We're just, in this decree, there's more opportunities to use them. That's a fair assessment?
Yeah, I guess the way I'd put it is, since 1985, so what, 37 years, there have been waters closed to gill nets. And those waters are now proposed to be open to gill net fishing. It's as simple as that.
And this has been based on negotiations with the coalition and the sport fishing groups in exchange for percentages of the quota and other things that were written in the previous decrees. Is that correct?
In the past, yeah.
Yes.
I mean, obviously, we were not supportive of the massive expansion of gill net water in this draft decree.
But that's the intent of the decree in general, is to allow for these negotiations, kind of give and take amongst the interested parties.
Right.
So I feel like this is a good question that is more pertains to, that you can give a great answer to. With the latest draft of the decree that is out, what specifically does the coalition want to see changed? Do you think there's benefits for both sides, like what the DNR has expressed that there is?
Well, there are lots of things that we would like to see changed to tighten up the language, because it is so vague as to be virtually unenforceable. The second thing is there is the provisions of this decree, I think, will have a significant negative impact on lake trout rehabilitation. And as much as we pursue silverfish, you need two species to have a really successful sport fishery, because you don't always have the species you might like to pursue available to you. And we've seen that in the lakes with the changes in the lakes just in the last 5 to 10 years. So the concern that we have is that lake trout rehabilitation is under serious attack, and we find it kind of a head scratcher that when the rest of the world is moving away from gill nets because of their non-selective nature, and because of the ease with which they can be used to target specific areas, all of a sudden we're expanding gill net opportunities throughout the lakes, and going in exactly the opposite direction. I mean, if you think about it, in 2000, we took 14 million feet of gill net out of the lake. If that 24,000 feet that's allocated to Big Bay to Knock is fished 50 days, that's 1.2 million feet of gill net in the year, just in Big Bay to Knock. So that's the kind of thing that is just a head scratcher for us. It doesn't make any sense for the resource. It doesn't make any sense for lake trout rehabilitation. It isn't sustainable in a long-term fishery. And you know, and let me say this. There are those who will say, well, trust us, we will make it all work out. And many times that may be the case. But I'm really dating myself now, but it was Ronald Reagan who said, trust, but verify. And the verification is lacking in this decree.
Well, and I think you kind of hit it on the head a little earlier in that statement, is that, you know, we all have a great relationship currently, really. I mean, you know, the tribes, for the most part, are a part of our social environment and our society, and we're a part of theirs, and we all are working in this great coexistence. But that can change. And you said it, you know, every 4 years you know, a lot of things can change, especially in the way that our government works. And by having a document that lasts for 24 years with a lot of kind of loopholes written into the document, or a lot of things that say, well, you know, we have faith that you're going to do the right thing. And I hope that that's true. And I hope that a lot of this is not a concern. You know, I would hope that people would commercially fish with less,
maybe more selective means.
Yeah, more selective means. Yeah, you know, I am against commercial gill netting. I don't think that. I think that it just is too much of a risk to the environment and to the fishery as a whole. But you know, that's not something that we can control. But we can control the language that's in the document.
Let me be very candid about the relationship with the tribes. I have a huge amount of respect for the tribes. I think some of the tribal representatives are, you know, nothing but good people acting in good faith on behalf of their tribe and doing the right thing. I have, you know, butted heads with Bill Rastetter from the Grand Traverse Band for 35 years, and I consider him to be a friend and a hell of a good lawyer that has only the best interests of the fishery and the Grand Traverse Band at heart. But Bill's about as old as I am, and we're not going to be here in the next 20 years. And the real question is, what do we leave in the way of obligations, and what do we leave in the way of standards and expectations for those that come behind us? And that's where this decree is sorely lacking. And that's what desperately needs to be fixed, because we can have a great conversation between the local sport fishing community and the Grand Traverse Band or the Little River Band or Bay Mills or Little Traverse. But what are we leaving for the next representatives and the next group that's coming along? And that's what's completely missing in this decree. And I'll, you know, I don't know if we're wrapping this up, but I'll leave you with one example of that. There is a provision in the 2000 decree that says, it's entitled Local Consultation. And it says that upon request, the tribes shall meet with local governments and local sport fishing groups to work out their differences. And we weren't at the table or even in the room or allowed to comment on changes that were made to that. And the changes that were made to that were to take out that language and put in language that says the state may request a meeting with the tribes to discuss local issues. And if the local community has an issue with the tribe, it has to ask the state to set up a meeting with the tribe. And doesn't say this, but implicit in that is the state can say, no, we don't think it's that big a deal. Or they can say, well, we have other issues that we think need to be addressed. And so what was a local issue and opened lines of communication between the tribes and the local communities, which I think served a tremendous purpose in terms of trust and communication, now is changed to where everything has to go through the state, and the locals have no ability to ask the tribes to sit down and meet, and the tribes must respect that request. The tribes can voluntarily do it, but they can also say no. Whereas before, the local community was allowed to request a meeting and the tribes had to sit down with the local community. Now, the tribes may have wanted that language taken out, but I think that was a mistake. And I'm sure the state put that in thinking they were doing the local communities a favor. But it's a local issue. It's not a state issue. And the state has other issues with the tribes that can get bogged down, that can be traded for a local issue. And in fact, at one point during the negotiations, somebody said, we don't have time for local issues. And that told us all we needed to know.
Yeah, that's a kind of scary statement to have made. You know, I do want to say, you know, in Ludington, we have a very good fishing community, and that community includes tribal fishermen, and we all get along, and we share information, and we help each other out. There was a point 2 years ago, we found I don't know if it was a net or if it was a line or something, but recreational fishermen were getting hung on it. And our tribal fisherman, you know, went out there on his own recourse and took that line out of the water, whether it was his or something left from previously. So, I mean, I think that we can all work together. We can, you know, if you're fishing in areas where there's commercial fishing, you have to be aware. You have to be aware that there could be commercial fishing in that area. You have to be vigilant. You know, most of the problems that I have ever had with commercial fishing gear, I would say were 99% my fault for not paying attention and running into commercial fishing gear. Mm-hmm. I mean, if you're in an area where there could be for commercial fishing gear, you know, it's kind of on you to, and if you look at the Coast Guard rules, you always must have a lookout posted. So, I mean, technically you were in the wrong if you run into marked commercial gear. Now, something that's unmarked is a whole nother scenario. I think we're at a point, like Steve, I mean, I appreciate your knowledge, and I wish that I could, to have an understanding of this much that like what you have, and being able to look at, I applaud you for being able to keep a open mind and looking at it from every perspective, and not just this perspective of the coalition or just the perspective of the tribe or anything. I think there's a big picture here, and there's a lot of different ins and outs and moving parts, and it's hard to have a grasp of the whole scenario, for sure. We truly appreciate you for being on here with us. I know that you guys are as passionate about sport fishing as we are, but I think you also have a very good grasp of the environmental aspects of all of this, or ramifications that could be there, and you show great concern with a lot of things, and as do we.
Well, I really appreciate the comment. I really come at this from the perspective that we need to set up a system and an agreement and an understanding between us that is not subject to mischief, and that we're doing a 24-year agreement, and we're only assessing stocks every 3 years. And we can't afford to have sloppy language, incomplete language, ambiguous language that creates an opportunity for mischief, because we're not all going to be here. As I said before, it's going to be other people looking at this decree in the future and deciding what are our obligations, and maybe we want to avoid some of them, and let's see if there's a loophole we can get through. So that's a huge concern. And then the second concern is, I just think there are things being done in this decree that are not sustainable and are not good for the fishery, particularly when it comes to lake trout rehabilitation, which I'm a huge fan of. You can't expand non-selective gear when you're trying to protect one species out of dozens. You can't fish on top of a lake trout refuge thinking you're not going to catch the fish that are moving in and moving out, or the fish that are resident on that refuge. I mean, think about the Lake Huron refuge that's half the size that it was for the last 37 years. It's going to be half the size that it was in the coming decree. And lake trout is experiencing natural reproduction in Lake Huron, unlike Lake Michigan, and is really the sole source for lake trout in Lake Huron. And here we shrink the refuge by half, and we allow gillnet fishing over the top of it 10 months out of the year. There's a sustainability issue there that has to be addressed.
Yeah, Steve, thanks again. Thank you so much for taking the time, out of your own time to come and help, expand the knowledge. I think our goal on the show is to try to bring truthful, objective information to the public. And I think you brought some really good points up about how you have, some mutual respect with the tribe. And we share that sentiment. And as such, we would really, really like a representative from the tribe to come on and talk with us in a fair way, like we have with the state, like we have with you. And, again, we're trying to be open-minded. We really want people to form their own opinions based on truthful information, make an informed decision about what's going on, and figure out how to move forward. Because like you and like the tribe, we think that what's really important is what happens for the generations to come, what happens for our kids and our grandkids. And I think the tribe has the same interest. So hopefully we can continue this conversation.
Yeah, I really definitely put that invitation out there. But also, if there's someone else that we should, have on that could answer some questions for people, or that would maybe give us another perspective on this whole thing, we'd love to talk to some more people as well. So, Steve, if you have any ideas, or if any of, the people watching, if you have something, feel free to comment in the comments here. Also, you can email me at adam@real2realoutdoors.com anytime. I'll try to respond as quickly as I can. If you're watching this, you didn't get to see the whole program, or you missed the program that we did with Dave Carafino from the DNR, that's all available on the YouTube channel, also on Real to Real Outdoors Facebook page. And this entire broadcast tonight will be available, let's just say an hour after that we conclude here. There's a little bit of rendering that has to happen, and then that is available in its entirety. So please, check that out if you have any questions. There's a lot of great information in these 2 episodes. Also, if you feel like you don't have a voice, if you feel like you're not being heard, the coalition is your voice. And so please consider donating to the coalition or supporting the coalition in some means. Spread the word about the coalition. Those kind of things go a long ways in our industry. So,
Steve, can you give the coalition website? Do you know?
I don't know it off the top of my head. I should.
I think it's
but I
My
don't.
Resource. Is
But-
it My Resource? That's MI Resource, I believe.
I think it's miresource.com.
Yeah, I think that's right.
And if you Google Coalition to Protect Michigan Resources, you'll go right to it.
Yeah, myresource.com, miresource.com to get involved and figure out how you can support the coalition. Also, guys, if you like what we're doing, please hit the like button and please subscribe to our channels.
definitely.
Because this is we're going to keep working. We're going to keep bringing more information, not only on the consent decree, but also just on fishing in general. We really want to expand the channel. We want to grow this thing. So help us out and smash those buttons for us.
Yeah, hit the like.
By the way, Amy Trotter just put up the actual
okay.
website.
Protect My Resources. Okay.
ProtectMyResources.com.
Thank you, Amy.
Yeah.
Amy is from the MUCC, another great organization that looks out
She's the
for
executive director of MUCC.
So, So there again, thank you, Steve. Thanks for coming on and giving up a little bit of your whatever day today is. Thursday evening. Yeah.
Christmas Eve.
And thank you for the opportunity. Really, I appreciate the opportunity to have this discussion, and I look forward to answering questions in the future if you have them.
Thank you so much, Steve.
Absolutely. Thanks a lot, Steve. Thank you again, everybody, for tuning in, and we will be sharing more information with you soon. So keep an eye on the Facebook pages and YouTube for more information. Have a wonderful, happy holidays to all of you. Be safe in Snowmageddon, or whatever they're calling this. Elliott, snow.
Has a name now?
Yeah, they call it Elliott.
Oh, Elliott.
I know this guy named Elliott, and he's kind of like a blizzard, snowstorm. So, be safe. Enjoy some time with your families. And just think, it's only like 4 more months till we control again, at least in southern Michigan.
Yeah, we'll see you there.
Yeah, if you live in northern Michigan or like Lake Superior, you can't troll till July. So, but we get to troll in April. So, hopefully,
take care and happy holidays.
All right,
Thanks,
we'll
Steve.
see you guys.
Take care.
Thanks.